Welcome everyone to Spotlight on State Law, Paid Family and Medical Leave. Thank you all so much for joining us. Our moderator for today's call is Beth Allen. She will be answering the questions you sent through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Jill Brooking, Vice President of Benefits Compliance at NFP, and Yoko Yoon, Director of Benefits Compliance at NFP. We're very excited to have them speaking with us today. It is my pleasure to hand over the call to our speaker. Jill, the floor is yours.
Thanks. I'm so glad to see so many of you here today to talk about leaves. So I just want to set the stage, I just want to set the stage and say that we are going to focus on the statutory disability and paid family and medical leave laws. This is in partnership with the white paper that we just released on the same topic. So we will not be discussing all the state leave laws. We won't be talking about earned sick leave or different versions of FMLA. We are focused on these. We may mention those other things, but this is the focus today. So as Amber mentioned, it is me and Yoko today, and then Beth is going to be answering the questions. We will do the live Q&A part with Beth at the end. We have a lot of content we want to get through, and always, especially on this topic, there are developments all the time, and so this is current as of today, and we're just giving you some general information. For specific questions, you're going to want to look at that white paper, and you're going to want to send us questions offline, like through your consultant. And then for leave policies, you would want those to be reviewed by outside counsel. So we love doing a poll. And so here's your poll for today to get you started with some participation. So how do you feel about states' paid family and medical leave compliance requirements and administration? 1, hey, you feel confident. You understand the latest state rules and developments. You're on top of it. B, we're somewhat aware of what we need to do to comply and administer it. So, we're kind of in there. Or 3, we are overwhelmed with all the new changes in different states and we feel lost. So first one, hey, we're feeling pretty good. Second one, we're all right. 3, no way, we're overwhelmed. So pick that. Okay, and where are we? All righty. So we have a few that say, hey, we're confident. Something tells me that's the team members and the consultants that might be on the call. The second one, that's about where I would expect you to be. There's so much going on, and you may be even moving into new states. So this may be a new requirement for you. And then the last category, hey, that's a third of you. So that's why we're here, because this is overwhelming and it is a lot to go over. So no matter what category you're in, I hope you learn something today and have some takeaways. Okay. Yoko, was I going to do the agenda, or do you want to do this? Yes. I can do it.
Thank you, Jill.
Okay. So we're going to do, as I mentioned, but the way we've organized this, we have the upcoming ones. We have 3 states that are not in effect yet. They're going into effect in 2023 and 2024. So even if you're on top of the ones that are in place now, you want to know what's coming down the road. And then what are the current ones that are in place, the existing ones. Then we're going to do FAQs, kind of a discussion, and then we're going to do some practical tips and considerations for you. And then we have resources, and there's just going to be a screenshot, but we will reference them as well. And then we will do the Q&A with Beth at the end. I just want to say this ahead of time. Normally, we give those of you that registered ahead of time, we give you a copy of the slides and the recording by Friday. But we have some people that are on spring break this week with kiddos. And so we will not get that out until Monday. So if you don't get it on Friday, there's a reason. You'll get that on Monday emailed to you. Now, when we talk about this today, you're going to hear us. We're going to try to distinguish between which states have the disability part, statutory disability, which is kind of paid medical when you think about it, and then paid family. But sometimes some states call it paid family leave and it includes medical. So we will say PFML or we may say PFL. So really just look at the slides to see if it has disability and medical as part of family. And then also the white paper will say that too, but we'll try to be consistent with that. Okay, Yoko. And look at this beautiful map she did. She did this.
Jill. Yeah. Thanks, Jill. So like this slide shows a quick snapshot of the states currently enacted. As you can see, like some of them are already in force, like California, Washington State, New York, New Jersey, but the ones in the reddish, orangish are up and coming that Jill is going to go over after me at the next section. That will include Colorado, Oregon, and New Hampshire. All right, next slide, please. Sorry, Jill, next slide. Thank you. So like before we get into like each state's PFML key highlights, we would like to paint a big picture of some like confusing like terminologies and states laws that are kind of like integrated and coordinated with the state's PFML. Just to step back. So as you can see on the top, so the top section is a mandatory that's usually enforced by the states or city level or counties. And then the second portion is some of you may already have STD policies or LTD policies, or in addition, you may provide a maternity leave or parental leave. So those are optionals, and that may coordinate with the state's PFML, depending on the qualified reasons. So the top one is paid sick leave law that comes up time to time, especially with the COVID. It could be enforced at the state level, it could be county. It is a confusing laws actually, but usually it's very different from the when we talk about the state's PFML, because the paid sick leave is usually just the accrual of the PTO. It's not so much going through the state fund, the state program, like insurance. It's not so much of the insurance. It's more like employers are required to provide minimum amount of sick days per year for certain reasons. And on the other hand, some states that you saw on the map on the previous slide, that enforces the family leave insurance component and also the medical leave insurance. And medical leave insurance is also known as a statutory disability. That is to cover employees' own serious health condition. And family leave is for employees to take time off so that they can care for their family member or to bond with the child. And I'm sure like you have encountered many situations with the employee go on leave for the pregnancy, maternity, and followed by the bonding leave. And usually what happens is that pregnancy incapacitated due to the pregnancy is covered under the statutory disability, so medical leave, and then run concurrently with the STD if you sponsor STD. And in addition, if you are subject to FMLA, the FMLA which is the unpaid job protected entitlement leave that will run concurrently. And then after a child is born, the family leave insurance will come into play. So the time take off after the child is born, it apply to both mother and fathers. And to bond with the child will be family leave insurance. And on the right side, the box that just made a quick distinction between the unpaid job protected leave entitlement, which is FMLA. In some states also has their own version of it. And that's different from when we talk about states PFML. So FMLA, the state's FMLA version, state's version of it is unpaid, but it's job protected when it runs concurrently. So you're not permitted to terminate an employee when FMLA it runs concurrently with this STD, or it could be a medical leave insurance. Versus the state's PFML, depending on the state, that includes or sometimes it does not include job protection. Next slide, please. So due to the space of the slide, we did not include all the information for each state, the highlights. So just this slide kind of outlines what are the commonalities among states' PFML programs. The important thing is the question that we often get is that which employer needs to comply with the state's PFML. And generally speaking, if you have at least one employee who works in that state, regardless of where that employee lives, you are subject to that state's PFML. That will include the notice requirement, quarterly reporting, need to withhold employee contribution through the payroll. So for example, if you have an employee who works in New York but lives in Connecticut or Pennsylvania, you're still subject to New York PFL. That'll be the example. And just a quick notice, like federal FMLA, state version of Family Medical Leave Act, generally do not apply to small groups. So there's a slight difference there. And if you're not sure whether this employee is subject to which state PFML, it doesn't apply all the time, but generally speaking, if you pay for the state's unemployment insurance, that state's a PFML program usually apply. And quickly, let's see. Right, so the eligibility of an employee to able to receive benefits through state's PFML is that it's different from the FMLA. FMLA has more strict eligibility. The employee needs to work for 12 months at certain hours, but usually eligibility for state's PFML is determined based on the earning. So how much they had been contributing to the state program. Therefore, they are eligible to receive the benefit when the qualifying reason occurred and need to take a leave. And lastly, the qualifying reasons for the leave include, but you can see state's PFML, as long as that includes both the medical leave disability portion as well as the family leave portion, it's very similar to the federal FMLA qualifying reasons. But in addition, some states like New Jersey or Colorado includes new additional qualifying reason like safe leave to seek assistance, take time off to seek assistance for domestic violence or sexual violence offense. But even though the qualifying reasons are very similar to federal FMLA, main difference is the definition of family leave. The state's PFML covers additional family members or become eligible for family members. For example, some states include family members as grandparents, domestic partner. And this is a new trend that we have seen, is that in addition, there's a category called with whom the employee has a significant personal bond that is like a family relationship, such as New Jersey and Colorado. So And more it's hard to kind of distinguish by the states which family care that they're taking up time off for and who are the eligible family members are. Next slide, please. And I'm going to hand it back to Jill for the upcoming new state PFML.
Thanks, Yoko. I want to point out a couple of things that she mentioned that are really important distinctions. And she talked about the difference between leave entitlements, excuse me, and job restoration versus being on leave. We get the question a lot about, hey, so an employee is on short-term disability and they have been for a month. When can we terminate their benefits? And we'll talk about benefits eligibility at the end, but when can I terminate their benefits? Well, short-term disability is not a leave entitlement. That's how they're getting paid. That's wage replacement. So what leave are they on? Are they on FMLA? And some of these laws have leave entitlements, meaning that that's the leave they're on, and the state law requires you to give them leave if they're qualified, restore them to the same or similar job, and continue their benefits. Some of them don't require those things, and so we'll indicate on each of these slides, and the paper also indicates that. There was one other thing that I wanted to mention. It may come to me. So let's talk about the ones that are coming up now. So Colorado is one of the states, and they call theirs Family and Medical Leave Insurance, FAMLA. And so deductions will begin January 1st, 2023, so coming up next year, but the benefits are not going to be available to employees until January 2024. So that gives an entire year of pre-funding the plan. So a lot of you have already asked, hey, we have one employee in such and such state. Does that mean we're subject to it? Generally speaking, as Yoko mentioned, most of these will apply if you have one employee working in that state. And working means that they could be working from home. They could be telework. Everyone could be in Virginia, but you've got someone working in California. Well, more than likely, they're going to be subject to the California State Disability and Paid FMLA, the one employee in California. But where that's different, we will note it on each of these. But that's why this topic is so important right now. We are getting questions all the time from employers that say, hey, one of my employees just moved to Hawaii. I know, good for them, right? One of my employees moved to Hawaii during COVID, during the pandemic, and they've permanently moved there. What do I need to know? It's more important than ever to figure out where your employees are working and for how long, because we've always thought about state taxes, unemployment, insurance, but you should be thinking about workers' comp as well, and these state requirements, disability and paid family leave. So Colorado, the covered employers are employers with at least one employee who works in Colorado during 20 or more calendar weeks in the current or preceding year, or a wage requirement, $1,500 in a quarter. So this isn't going to be triggered if just one employee goes to Colorado for a month. But if you have an employee, just one, permanently working in Colorado, yes, this is going to be triggered for you. There are some exceptions, and we've noted those. This is going to be pretty consistent on every slide, that federal government, local government, and self-employed are not covered. Self-employed may opt in, though. Funding for the program, this varies quite a bit, whether it's employer or employee paid. And this one varies by size. And so if you have fewer than 10 employees, you are not required to contribute to Colorado. It would be 100% paid by employees as a deduction of their wages, 0.9%. So that's less than 1% of taxable wages. And then if it is employers with 10 or more, you'll split it down the middle. So 4.5, 0.45%, I should say, and 0.45% would be paid by both employer and employee. The maximum benefits amount is 90% of the average wages up to a maximum of $1,100 a week. So at first, 90% sounds, oh, wow, but then it is a cap of $1,100 a week. The maximum benefits duration, it is 12 weeks in a 12-month period. So that's going to be pretty standard. The FMLA is 12 weeks, if you're familiar with that. And so those are unpaid, but this would be 12 weeks in a 12-month period, and then an additional 4 weeks of leave if the employee is incapacitated due to pregnancy complications. You'll see that as well. Some of them have additional time for prenatal or pregnancy, and this one is pregnancy disability complications additional, so that'd be 16 weeks. Colorado is also one of the states that includes safe leave, and safe leave for this state is defined as a victim of domestic violence, sexual assault, stalking, or abuse. The Colorado provisions for the job protection, leave entitlement, and health plan eligibility, it's only for those with 180 days of employment with the current employer. So you wouldn't have an employee, on week 3, new hire, that says, hey, I'm taking Colorado family and medical leave. The job restoration and eligibility part is only for those that have been there basically 6 months. So just a quick little page on Colorado, since it's upcoming. This is your little checklist. You need to register with the Colorado FAMLA division, but it's not yet public. Consider your plan options. This is one of the states that gives you a choice. You can just contribute to the state program, or you can get private insurance. Private insurers, not yet announced. You'll need to update your leave policies, of course. Communicate to the employees. The poster is already available. You might not want to communicate just yet since all the details aren't available. Set up payroll deductions. And then, as always, the NFP biweekly newsletter Compliance Corner that is sent to you by your consultant or your local office. We will let you know when the registration for Colorado opens and when the insurers have been announced. New Hampshire, this is the second state that is upcoming. Just to be clear, this is optional for private employers. It is required for state government employers of any size, but private employers with more than 50 employees may opt in. So I know that a lot of employers are not going to voluntarily sign up for leave if they don't have to, but this is a program if you're looking for one in New Hampshire. So the effective date, benefits would become available to employees on January 1st. And for private employers, the insurance part of it has not yet been announced. The covered employers, again, private employers with 50 or more, you can choose to if you want to. This is an insurance program for the private employers. The insurance premiums would be charged by the private carrier, just like a disability, just like a short-term disability would be. And then the private employers can choose to pay all, some, or none of the cost. And then average maximum benefit would be 60%. And that's pretty average for short-term disability anyway, would be 60%. And then the maximum benefits duration is up to 6 weeks per year. We have very little information on New Hampshire. There's not a website that we can point you to. It's just, so when you go to our white paper, you'll see it's just a link to the law. So hopefully we'll get more information on this later. And job protection and health plan eligibility, it does appear so if you choose to offer this. So again, very little known about New Hampshire. Might be wise to take a wait and see approach until everything's hammered out. But if you are eligible to participate, 50 or more employees, do you want to? That would be a business decision. If yes, explore the insurer options where they become available. Determine whether you will cover any of the cost. You could just make it available to employees and not pay any of it. As always, we're always going to say update leave policies, communicate to employees, set up payroll deductions, if any, and check Compliance Corner for updates. You'll hear me say that a lot. And then the third upcoming one is Oregon. Paid Family and Medical Leave, PFML is what it's called there. And then the benefits will become available to employees on September 1st, 2023, and contributions begin January 1st, 2023. So this is an odd one in that it starts in the middle of the year. That is unusual. Typically, we see these things happen on January 1st. So next year, you'll be starting the contributions on January 1st, but then September 1st is when the benefits will actually become available for employees. Covered employers, here you go. Any employer with one or more employees working in Oregon. Excludes self-employed, federal government, and tribal government unless voluntarily opting in. So you have one employee that has moved out to Oregon and they work from home, this will apply. The funding is 1% of employee wages, a full 1% of employee wages up to the maximum wage base of $132,900. If you have 25 or more employees, you must pay at least 60% of that cost, with the employees paying the remainder. So if you're a employer with 25 or more, you have to pay at least 60% of the cost. You could choose to pay more. And then employers with fewer can choose to pay all, some, or none of the cost, but you would still have to offer it, even if you have one. Maximum benefit amount, it's the sliding complicated scale with calculations, but for up to 100% of weekly wages for lower paid employees, depending on how they compare to the state average wage. And then for those that are more moderate salaries, it could be 65% or more of their normal weekly wages. Again, maximum benefits duration 12 weeks. You're going to see that a lot. That's standard. And they call it a benefit year. That means that it is employer designated. That is not a calendar year. It's 12 weeks in an employer designated benefit year, and an additional 2 weeks for the disability related to pregnancy or childbirth. You'll start to see some patterns after a while. An additional 4 weeks of unpaid job protected leave may be available under the state's family leave law. They have an additional law that provides for additional time. And then total leave can exceed 18 weeks in a benefit year. And don't feel like you have to keep writing notes on all these. Remember, it's all in the white paper. And then job protection and health plan eligibility continuation. Yes, this is a leave entitlement. They would be returned to the same job. They would have the benefits continuation, but only if they work for one of those employers with 25 or more employees, and they have worked for the current employer at least 90 days. So it's not just everyone. And then your to-do list for Oregon, review your current leave policies. If you have an equivalent program or you're more generous already, you can file for an exemption from Oregon. But this process is to be announced. It hasn't, nothing's finalized yet. And then the same ones we've been talking about. You'd have to update your leave policies, communicate to employees, which is typically the poster if the state releases it. Set up payroll deductions, and then check your compliance corner, and we'll let you know when posters and the exemption process is released. This is just to put it on your radar. Okay, I'm going to pass it over to Yoko now, and she's going to tell us about all the ones that I just talked about are upcoming. Now we're going to talk about the stuff you should already be doing. This is the scary stuff. Okay, East Coast.
Sounds good. So let's get started from the East Coast side, and Jill is going to review the West Coast and the Midwest. So for the first state, we're gonna go take a look at it, is Connecticut. So I'm sure if you have employees, at least one employee who works in Connecticut, you have to collect employee portion of contribution from last year. And then this year is the first year as of 1/1/2022, that benefits became available to employees. And just a quick footnote there in the gray font, in case you forgot to collect employee portion of contribution last year, the state provided a catch-up period to recoup employee contribution that will end at the end of this month. So that will be the higher employee contribution to make up for the missed contribution from last year. And as other states, as it is the same for the other states, you'll be subject to Connecticut paid family and medical leave program if you have at least one employee who works in Connecticut, except for some government public employees that are noted there. And the maximum, so it's compared to other states, the maximum benefits amount the employee can receive if there's a qualifying event is pretty high. As you can see, 95% of employees average weekly wage, but up to the 780, and that'll go up to gradually. July this year will be 840 and 900 next year. So gradually it will increase. I don't know why it doesn't increase annually, but along that timeline there. Yeah, so next slide, please. So the next state that we are going to take a look at is the Washington, D.C. It's also called like DC, like PFL, also called Universal Paid Family Leave. This was enacted in 2020. So some of you are subject to DC PFL, maybe already complying with this for a few years now. And this is such a unique program because other states that you saw, like some states, PFML requires 100% employee contribution, or some states both combo of employee and employer contribution to fund the program. But unlike other states, DC PFL requires 100% paid by covered employers. So again, this will apply if you have any employee who works in DC, regardless of where that employee reside. So it could be someone work in DC but live in Maryland or Virginia, then you still have to contribute to this program. And the good news is that effective July, this was like very, very recently announced, that because they have little extra fund, there weren't many claims that as expected. So because of the surplus fund that they have, they are going to reduce the employer contribution amount currently 0.62 to 0.26 effective July 1st this year. So we'll keep you updated through our bi-weekly newsletter and other means to inform you the most updated. It's just that, so this is a target date for the reduction will kick in. And for the maximum benefits duration, it depends on the qualifying reason. As you can see, there are, if it's bonding, 8 weeks, to care for a family member is 6 weeks, and to care for employees' own health condition is 6 weeks. And this is new that are applied from, I think, last October, late September, is that in addition to these qualifying reasons, they also implemented the additional 2 weeks to care for the prenatal care. So this is prenatal care will apply for example, take time off to visit OBGYN or any other time off that employee needs before the child is born. So that will be in additional 2 weeks. And then so effective along with the employer contribution will be reduced. Effective July 1, the maximum benefits duration will also increase from currently 8 weeks to 12 weeks. And we'll also getting trying to get some additional clarification about whether each qualifying reason maximum duration will also increase or not. And the next is maximum benefits amount. Is pretty high also, 90% and up to $1,009 per week. Next slide, please. So the next state we are going to take a look at it is the Massachusetts paid family and medical leave. So it's been around for a few years also. It kicked in last year. And again, it applies if you have at least one employee who works in Massachusetts. And the contribution split, it varies by the size of your employees, and that 25 threshold is counted based on the number of your employees in Massachusetts. So it does not include your other employees in other states. So if you have fewer than 25 employees in Massachusetts, and that you're not required, you as an employer is not required to contribute. And then the maximum benefits amount is varied by each employee's wages, up to $1,000.31 for this year. And then the maximum duration is outlined there. The longest is to care for employees' own serious health condition is 20 weeks. And the caring for family member bonding is 12 weeks. And the caring for a covered service member is 26 weeks. And that Massachusetts PFML includes job protection. And employers are required to continue a health plan while on the leave. And some of the other states that I want to make a note is that if you're subject to the state PFML, then you're required to complete and submit the report and contribution to the state quarterly basis. And next slide, please. Okay, so we're gonna look at the New Jersey state. So this is like one of the oldest state that's been providing the statutory mandatory disability insurance and family leave insurance, and they call it TDI and FLI. And again, some of the other states, if you have any employee who works in New Jersey could be working from home, but the primary work location telecommuting is in New Jersey, then you're subject to New Jersey TDI and FLI. And they do offer a private plan, but it seems like most of the employers choose a state program. And the good news is compared to 2021, the contribution for employee and employer decreased significantly for 2022 contribution amount, as you notice, if you are being paying for New Jersey TDI FLI for a while, so it's a good news. And the benefit amount is actually increased too. And then it will be 85% of employees' average weekly wage up to $993 per week for this year. And maximum duration to take leave for employees' own disability is 26 weeks. And to care for family member, that will include the bonding leave, will be 12 weeks. And and just one quick note is like back in 2020, a few years ago, the governor increased and hence the duration amount of the length, and then the benefits amount the employee can receive significantly. So you may notice like the pre-2020 and after 2020, how rich the program became. Okay, the next slide, please. Okay, so the next one is in New York, DBL and PFL. I think many of you have employees maybe working in New York State that are subject to DBL and PFL. And as you can see, DBLs were enacted, was implemented like many years ago, and PFL came into play a few years ago. So as you can see, the contribution amount is split between employees and employer and depending on the carrier as well. But the PFL contribution amount is the same regardless of which carrier you are getting that policy from. And then DBL and PFL is usually a rider to DBL. So it's a one policy. So if an employee is subject to DBL, then automatically the employee is subject to also PFL. So the employer is purchasing one policy that includes both DBL and PFL from the approved disability carrier. And the maximum benefits amount is, this is the interesting part. As I mentioned, DBL has been around for many, many years because it's statutory, I guess it's in the law, so they haven't been able to increase the maximum. So DBL to care for employees' own disability is up to only $170 per week. On the other hand, PFL to care for family member, it's 67% of the employee's weekly wage, up to $1,068.36 for this year. And maximum duration, DBL is up to 26 and PFL is 12 weeks. Next slide, please. Okay, the last slide for East Coast is the Rhode Island TDI and TCI, temporary disability insurance and caregiver insurance. Also, Rhode Island's being around for a while. Their program has been running for a while. And as you can see, like the medical leave is similar to other medical leave as under disability insurance is very similar to other states, but the family leave is more limited than the other states. They haven't changed and hence the family leave insurance portion that much. But yeah, the maximum benefits is all for this year is up to $978. And the maximum benefits duration is 30 weeks to care for employees' own disability with serious health condition and to provide family care, to bond with a child, to care for family member is 5 weeks this year and then go up to 6 weeks next year. And I'm gonna hand it back to Jill to go over the West Coast.
Thanks, Yoko. Yeah, that was a lot of work. She did the most, and I have like two, but I have one of the biggest ones. Okay, because when we think about generous leave laws, what state do we think of? Everyone together? California. Yes. So if you learn California, that's right, Cali. California is one of the older ones as well. And so it is broken up into state disability insurance, SDI, and paid family leave, PFL. So this applies if you have only one lonely employee working in California. Funding for the program, 1.1% of taxable wages. That's combined, 145,600. That's a combined for both SDI and PFL. And there are two distinct buckets because there are two distinct claim forms and divisions that process these. And of course, the disability is the medical leave part, the employee's own illness. And PFL would be for an employee to bond with a new child or to care for a family member. Also, they are one of the states with military exigency. And I always hate that word. I always have to practice on it before I do the presentation. Maximum benefits amount, 60 to 70% of wages up to a maximum weekly benefit of $1,540. Quick note here, San Francisco is always different, right? So if employee is located in San Francisco and the reason for the leave is a new child, birth, or adoption, then that employee may be eligible for 100% of their wages under the paid parental leave ordinance. So that means if I live or work in San Francisco and I am eligible and receiving a benefits paycheck from California paid family leave, then PFL will notify the employer and you have to make up the difference between the 60 and 70% that they are getting from PFL. And to make them whole, that comes straight out of the employer's pocket in San Francisco. The maximum benefit durations, SDI, 52 weeks. What? You heard that right. If someone is disabled, 52 weeks in California for state disability benefits. There's a 7-day waiting period on SDI. There's not a waiting period on the PFL. So if I am transferring on a pregnancy claim, and so the disability portion, I would have a 7-day waiting period. When the claim transfers over to PFL, there is no waiting period, and that is 8 weeks. So when I say 52 weeks, some of you might think, what? Do they get a whole year of leave entitlement and benefit continuation? No. So because California was one of the earlier states, this is not one of the states, but like Massachusetts or New York paid family leave, where just because an employee is eligible for benefits means that they are entitled to a job and they're entitled to the leave. No, they're not. But California does have extensive other requirements called California Family Rights Act, CFRA, and then there's FMLA. So if I'm disabled in California, I have leave entitlement under CFRA and FMLA, and that would cover 12 weeks. If it's pregnancy related, you would actually have additional time under PDL, pregnancy disability leave. But let's just go with a straight, I've had hip surgery. And so if I'm disabled in California, I could be leave entitlement and job restoration for 12 weeks under CFRA and federal FMLA that go at the same time concurrently. But I could be eligible for benefits at 52 weeks receiving them from the state. So we did receive a question earlier. So what does that mean? What do I do with that employee for the difference between 12 weeks and 52 weeks? Well, that's when you have to look at your own policies. Does it say, that employees continue for a period of time on certain leaves, some kind of employer provided leave? And then you have to look at your obligations under the Americans with Disabilities Act if you have to make an accommodation, including a leave extension. Okay, and then Washington State. Washington State, it's one of those two employers with just one employee who works in Washington. It is 0.6% of gross wages, excluding tips, up to $147,000. Employees are eligible. This is a big old post-it in the corner because I want to make sure you know this. Employees are eligible if they have worked 820 hours for any Washington employer in the last 4 completed quarters. You could have somebody that works there for 4 months and they're going to be entitled to this leave in Washington because they have worked enough hours under all employers in Washington. It's the standard reasons: new child, serious health condition, and to care for a family member. The maximum benefits available, 90% of weekly wages up to 1,200 max. Maximum benefit duration, 12 weeks of either leave. So I could have 12 weeks of the medical part and 12 weeks of the paid family. But combined, if I take them both in the same year, I only get a total of 16 weeks. And it is also one of those that has an additional 2 weeks for prenatal and pregnancy. It does have the job restoration and health plan eligibility, but it's only if the employer has 50 or more employees and the employee meets that service requirement of 1 year and 1,250 hours. Anybody know what that relates to? That looks exactly like FMLA, 50 or more employees, 1 year of employment, 1,250 hours. So yes, we got a question for San Francisco. Is it if you live or work there to receive that city benefit? It is if you work there. Sorry, that was a slip earlier when I said live. It is if you work there. Okay, So now we're going to do the next region, the other, Hawaii, and Yoko's going to do this. This is another one we always receive questions on.
Thank you, Jill. So Hawaii, only like currently Hawaii requires a statutory disability insurance. Although there was a proposal to add a paid family leave portion back in 2020, but it hasn't been finalized yet. So for now, if you have any employees who work in Hawaii, then only thing you need to focus on is the temporary disability insurance. And the compared to previous year and this year, there aren't many significant changes except for the employee contribution amount has changed, and also the maximum benefits the eligible employee can receive has also increased. And then the Hawaii, it's disability insurance is like the state does not hold a fund, so you'll be contracting with the approved disability carrier, and they'll be issuing the policy for you and providing that insurance to the employees. Next slide, please. And Puerto Rico, like not so many clients seem to be are applied to the statutory disability benefits program, but here are some key highlights. If you have any employees who work there, maybe relocated after COVID. So very similar to Hawaii, Puerto Rico does not have paid family leave portion, only have the statutory disability program, and requires both employer and employee contribution, and the maximum benefits amount is 65% of employees up to the maximum. Next slide, please. All right, thank you.
Actually, with 7 minutes, let's go ahead and do the considerations, and then we'll come back to questions. How's that sound, Yoko?
Sounds good.
Okay, so what should you be thinking? Because this is a lot of information and each state is different. While we try to give you generalities, each state really is different. You have to look at that one employee and where they're working. And I know everyone wants, the ease of administration and say, okay, well, can our PTO policies be used in the same time to make them whole? Some states yes, some states no. We can't give you an answer on all those. We can tell you generally that yes, that would be okay, but in some states you're specifically prohibited from that. So this really is, that's the way we are set up here. State rights and state governances, and states have the right for different laws to be enacted. And so when you have a remote workforce, or when you have a large company with national presence, you really have to be on top of each state. It's not like we can give you one policy that says, hey, you're good to go in all 50 states with this one policy. It's just not practical. So here are some practical tips for you. Review your employee work locations in order to understand which state programs you are subject to. Work with payroll to make sure that you're setting up the employee contributions for any of the programs that are upcoming or that you should have already be doing. Be aware that each state, again, has different eligibilities, contribution amounts, benefit amounts based on your size. Some of those new states, the Colorado, the New Hampshire, we're not sure how they count employees yet because we have very little guidance. Hopefully with them coming up next year or the next year, we will know by then. Register with the state departments. Some of these are done through the Department of Revenue when you file your worker or your unemployment insurance and your regular taxes. Some of them have different departments. Revise the employee handbook as necessary. The best practice is to have your main handbook that applies federal law and nationally, and then have an addendum that is for each state. Remember, states also have rules on when to pay overtime. Some of them, it is more than 8 hours per day. Some of them, it's more than 40 hours per week. So states already have different laws that should be in your handbook. So that's what NFP does. We have our main employee handbook, and then those working in Texas get a different addendum than those, say, working in New York. And then this is a question we get a lot, and I promised to cover this. So benefits eligibility during a leave of absence. When do you terminate their benefits? Eligibility and coverage continue during a leave if it's required by federal FMLA or state law. So if they're eligible for federal FMLA, always we continue their benefits at the same cost. We've tried to indicate on these slides, also white paper, on which ones require benefits continuation. That means the same cost they had as an active employee. We can't charge them 100%. You have a choice most of the time if you will require them to pay their missed deductions during the leave, or will you allow them to pay upon return? Whatever it is, you have to tell them what those procedures are. At the start of the leave, instruct them on if they have to pay you, what they need to pay you, and when. Okay, let's say that your obligation to continue their benefits is over under federal FMLA and state law. Now what? Now you look at what does your plan document say about eligibility? I looked at one the other day that said 6 months. So an employee that's on a 6-month leave of absence would have their eligibility continued. So follow that. If you use the employer look back measurement period because you're a larger employer under the employer mandate and ACA, if you're using the look back measurement method and this person is in a stability period because they earned full-time status, their eligibility continues through the end of the stability period, regardless of the number of hours they have worked, unless you have terminated their employment. Once the employee loses eligibility, coverage is terminated and COBRA is offered for reduction of hours. So many times we have employers that continue to offer coverage to an employee who was not eligible. I know you want to do the right thing, and it is so awkward to send a letter or contact an employee who really needs the coverage and say, hey, you're not eligible for the coverage anymore. It's terminated, and here's your COBRA letter. You have to do that because it doesn't matter if you're fully insured or if you have a stop loss carrier. If you're continuing coverage for an individual that is not eligible for coverage, the carrier can deny those claims or they can deny the stop loss claims, and you're left with all these claims that you would have to pay out of pocket. So follow the rules, terminate the coverage, and if you want to soften the blow, offer to subsidize COBRA coverage for a while. Okay, Yoko, what do we have as a parting gift for all of our attendees?
Great. I know I saw one of the comments as I agree with you that your head must be spinning. And it's a lot of information. And that's why we have resources to look back and like reference back. And you may not, like all the states may not apply to your group. So we have the first one is the latest one, off the press. It has all the statutory PFML disability insurance of all currently enacted states. So this resource can be helpful to look up. So what is this 2022 like employee contribution amount or benefits length? What do I need to do? What are the definition of family members? So that reference chart is a helpful guide that you can ask your NFP advisor for this white paper. And in addition to the quick reference chart, we also have most of the states' PFML like white paper that dives into the details of what each PFML requires and the to-do list. So we have those as well.
Yes. So thank you so much. We are at time. I'm sorry we couldn't get to you, Beth. I know you were typing furiously. Thanks for your work.
No problem.
Thank you.
Okay, Amber, close us out.
Thank you, Jill and Yoko, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.